Matter of hours, former President Jacob Zuma's urgent application to interdict his arrest will be heard before the Pietermaritzburg High Court. Zuma's applying to stay out of prison while he awaits a hearing before the Constitutional Court to rescind or set aside his sentence. In a watershed moment last week, the Apex Court sentenced Zuma to 15 months for repeatedly refusing to appear before the State Capture Commission. Zuma's imprisonment was expected to start on Sunday, so can a High Court, in fact, block a Constitutional Court order? Well, let's chat now to legal expert attorney Ulrich Roux. Ulrich, thank you so much for joining us. Does the High Court have standing to overturn a Constitutional Court decision?
Hi, good morning, Annika. Thank you for having me. Yes, that is the big question that the court will have to answer today, and that is, of course, that the Constitutional Court is regarded as our highest court in our country, and any Constitutional Court order is binding on any court that is below it. So in other words, on the Supreme Court of Appeal, the High Court of South Africa, as well as the Magistrates' Courts. And that is going to be Jacob Zuma's biggest hurdle to overcome, is whether he in fact has whether the High Court has the jurisdiction to stay the court order handed down by the Constitutional Court. Remember that he's launched an application to rescind the Constitutional Court order, so in other words, for the Constitutional Court to overturn its own order. But pending that decision, he's now going to the High Court in Pietermaritzburg to ask the High Court to say, well, you shouldn't, the order handed down must be stayed. They should not arrest me as per the Constitutional Court order, pending the outcome of my rescission application. Certainly, as you say, unprecedented applications being launched by Jacob Zuma.
I mean, his main complaint is that he has not had a fair hearing, he's had detention without trial, and that even one day in prison will mean he won't recover his health, dignity and reputation, are his words in his founding affidavit. In an ordinary situation, just say you're dealing with a client yourself and there is pending litigation, what would ordinarily happen?
Well, his difficulty is that as I said, you know, the Constitutional Court order handed down, as well as his rescission application, does not stay that order. It does not take the form of an appeal, which automatically stays in order. This is a rescission application. So, you know, the fact that he's complaining about his health and being incarcerated for even one day, unfortunately, is a secondary issue. The first issue is whether the High Court can even entertain his application, and whether it has the jurisdiction to do so. So what I expect the High Court to do today is to firstly get that issue out of the way. So in other words, say to Mr. Zuma, you need to convince us that we can even hear your application. You know, we hear what you're saying about your health and about the pandemic and all of these issues that you've raised in your application. You need to first convince us that we can even entertain it. And I think that is going to be the strongest argument of the Commission as well. They've raised it in their answering papers that the High Court should not even be hearing this. And, you know, that the Constitutional Court order should be executed. It should take effect as per the court order, and that the High Court does not have the jurisdiction to stay it. So just remember that what the order said last week, Tuesday, is that Mr. Zuma had 5 calendar days within which to hand himself over. Those 5 days expired on midnight or at midnight on Sunday, this past Sunday. And now the Minister of Police and the Police Commissioner, as per the order handed down by the Constitutional Court, needs to do whatever they can and whatever is within their powers and whatever is possible in order to give effect to this order. So in order to arrest Mr. Jacob Zuma so that he can start serving his sentence of imprisonment. Interestingly, the State Attorney has now sent a letter to the Constitutional Court asking for guidance, which I don't think is to be criticized too much. You know, there is quite a bit of uncertainty pertaining to these court orders, and I think that it is actually the right move by Mr. Tele to send a letter to the Constitutional Court to say, we will abide by whatever instruction you've given us. We take note of the court order handed down, but in light of these 2 pending applications, please instruct us as to what to do. So strictly speaking, from a legal point of view, if the application is dismissed today on grounds of jurisdiction, then Mr. Tele and the police commissioner need to execute the warrant of arrest or of committal, and that needs to be done before midnight tomorrow.
Very quickly, before you wrap up, if the relief sought by Zuma is not granted or he's not given standing to actually even have his matter heard in the Pietermaritzburg High Court, it's not a trial, but could he apply for bail?
No, he can't, because he's serving a sentence. This is not a normal criminal matter where a person is arrested, then given an opportunity to apply for bail pending the finalization of his matter. He's already been found to be in contempt of a constitutional court order, and he's already been sentenced to 15 months imprisonment. So no bail will be for an opportunity for bail will be afforded to him.
Thank you so much, Attorney Ulrich Roux. Thank you once again.